When it comes to the recognition of foreign divorce, having the right documents is only half the battle. A wrong certification, even one with a fancy gold seal, can lead to an immediate dismissal. Here is a breakdown of the requirements, the specific pitfalls of authentication, and the costs involved for 2026. To win a recognition of foreign divorce case, you must prove three things. 1. That one of the spouses was a non-Filipino at the time of the divorce. 2. The fact of divorce. And 3. The foreign law that allows it. We have organized the requirements into a clear hierarchy. Each document serves a specific legal function to satisfy the court's strict evidentiary standards. First, proof of citizenship can include the certificate of naturalization, if the foreign spouse is a former Filipino, or the foreign passport, including a previous one with its date of issuance prior to the divorce. Second are official divorce records, such as the foreign divorce decree or judgment. This is the primary evidence that formally proves the marriage was dissolved by a competent foreign authority. The certificate of finality, or its local equivalent, this vital document can confirm the divorce can no longer be appealed or contested, ensuring the judgment is permanent and executory. Next is the document needed to prove the validity of the divorce. You need to have an authenticated copy of the foreign divorce law, because Philippine judges do not take judicial notice of foreign statutes. The foreign law must be proved in the Philippine court. This document shows the court that the divorce is legally valid and recognized under the laws of the country where it was granted. It used to be that if you are dealing with a third country divorce, for example, a Japanese national who got divorced in the US, you must prove both laws. You have to prove to the Philippine court that the law of the US is valid and that the law of Japan recognizes that American divorce as final. This has changed recently because of the Supreme Court's ruling that proving the law of the country where the divorce took place is enough. And lastly, the subject matter. The marriage documents, such as the PSA marriage certificate, which serves as a target for the case. It is the official document that the court will eventually order to be annotated once the divorce is recognized. The report of marriage of a Filipino abroad. If your wedding took place outside the Philippines, this is required to prove the marriage was validly celebrated abroad before it was dissolved. In other cases where there are properties involved, property documents are also required, like the certified copy of title and tax declarations. If there are child custody or support issues involved, additional documents like birth certificates, medical and school records may be required. The chain of authentication, the apostille. The most common reason for delays, and in the worst case scenario, an immediate dismissal, is a break in the chain of authentication. People may believe a foreign notary's public seal is enough. It is not, at least not in itself. A notary only certifies that the person in front of them signed the paper. They do not have legal custody of the government record. To be admissible in the Philippine court, a document like a divorce decree or a foreign statute must be certified by the legal custodian. This is the official who actually holds the original records in their archives. One of the most critical mistakes petitioners make is relying on a private lawyer or a notary public to stamp a photocopy of their records as a certified true copy. In the eyes of the law, a notary's authority is limited to witnessing a signature. They do not in themselves have legal custody of the government or court records, and therefore cannot vouch for their authenticity. Only the specific legal custodian, such as the clerk of court for divorce decrees or the Ministry of Justice for foreign statutes, possesses the legal authority to issue an official certified copy. If the document originates from the wrong source, the entire chain of authentication is broken from the start, and the Philippine judge will be forced to reject the evidence because its origin cannot be verified. Since 2019, the Philippines has been part of the Hague Apostille Convention. This is a simplified process of authenticating the documents from other apostille countries to be valid and accepted in another. However, a lot of people still get it wrong. For countries that are members of the Hague Apostille Convention like the USA, UK, Japan, Italy, and Spain, the authentication process is streamlined into two essential steps. First, you must obtain the certified document directly from its legal custodian. Second, you must bring that document to the designated apostillizing authority to receive the apostille certificate. Once this certificate is attached, the document is fully prepared for the Philippine court, and no further stamp from the Philippine embassy is required. However, if you are in a non-apostille country like the UAE, China, or Thailand, you must still follow the more tedious red ribbon chain, which requires moving the document from the local court to the foreign ministry and finally to the Philippine embassy or consulate. Without that final embassy seal, the document remains legally inadmissible as evidence in the Philippines. If your decree or the foreign law is in a language other than English or Filipino, like Italian, Japanese, or Arabic, you face an extra hurdle. When dealing with documents in a foreign language, the critical rule is that the translation must be performed by an accredited or sworn translator to be recognized by the court. In many jurisdictions, this leads to what is known as a double apostille, where the translation itself must be physically attached to the original document and the entire bundle must be apostilled as a single verified unit. A common trap for many petitioners involves the location of the translation. If you have the document translated within the Philippines, we suggest that it be handled by a translator specifically recognized by the Department of Foreign Affairs, the DFA, or the embassy of the country where it originates. Conversely, if the translation is done abroad, it must be either apostilled by the Philippine consulate or apostilled within that country. Failure to follow these strict linguistic authentication protocols will render your foreign decree or statute inadmissible, regardless of how accurate the translation may be. 3. The cost of document gathering. Gathering these papers may be more expensive than people expect, particularly as they typically involve documents from outside the Philippines. For example, consider the need to get exemplified or certified copies from the foreign court. Then, after certification by the custodian, there are the apostille fees for each document. There can also be the need to obtain acceptable translations for a foreign document, because divorce laws can be long. Then there is the cost of the international couriers, DHL, FedEx, for secure back and forth shipping. There are also likely documents that have to be locally obtained from the Philippine Statistics Authority, PSA, the Department of Foreign Affairs, the DFA, or the Bureau of Immigration, the BI. These are needed in order for the lawyer to complete the petition and affidavit to be signed and notarized by you either abroad or in the Philippines. How long before we file? It is different for each case, of course, but before your lawyer goes to the courthouse to file the petition, every single piece of paper must be physically in their hands in the Philippines, as incomplete documentation is an immediate bottleneck. In reality, the preparation phase is often the most time-consuming part of the entire journey. You can expect months just to gather and authenticate your documents before your lawyer can even set foot in the courthouse. While ordering a document might take a few weeks, the authentication and apostille process is also a bottleneck, depending on the backlog of the foreign government or the specific state. If your documents require an official translation, you aren't just waiting for the translator. You must then have that translation separately apostilled or authenticated, adding time to the clock. Factor in time spent coordinating between different offices and the international shipping of heavy document bundles, and it becomes clear why you cannot rush this stage. Because a single missing seal can result in a case's dismissal, this lead time is your most important investment in a successful petition. It takes time, but realize this phase is the only document preparation. It does not yet include the entire time frame from filing to decision and post-trial registrations with the local civil registry office and PSA, which is its own topic for discussion. A single missing stamp or an unauthorized notary is a legal landmine. In a Philippine courtroom, your evidence is only as strong as the seal on the back of the page. Don't leave your future to guesswork. If you're starting to gather documents abroad, let us review your documents first to ensure your paperwork is trial ready. I am Attorney Francesco Britanico. Message us at FCB Law Office today, and I'll see you at the next video.